Hello, this is Scott Horton. I will be presenting today's webinar. We've just gone live, so we will give everyone an opportunity to get into the room, and then we will get started right on time. So again, as you're joining, this is Scott Horton. We're going to get started in a moment. Welcome everyone who's joining. You should be able to hear me and see the slide for the presentation. They cover New York wage deductions, what may companies withhold from workers' pay. You should see or have access to a chat window. And that is where you'll be able to ask questions in the presentation today. So again, we're going to get started in just a couple minutes to give everyone a chance to get into the webinar. Thanks for joining us. Just a couple more minutes and we will get going. Make sure you have access to the slide on your screen, New York wage deductions, what may companies withhold from workers' pay. And you have found the chat window, as that's where you can type in your questions. And otherwise, as long as you can hear me, you will be good to go. Welcome as you're just joining. We're going to get started in another minute or two. Just want to give everyone a chance to log in. This is Scott Horton. I will be presenting today's webinar. Just familiarize yourself with the chat window so you know where to type in your questions. As you have them, we'll go over everything again at the beginning when I get started in just a minute. Thanks for those of you who have typed in the chat. So we know that that is working. Certainly working on my end. Hopefully it means you can also hear me because I haven't seen anybody type that they were having any trouble with that. And with that, we're just going to wait a couple more seconds and I will get started. Okay, good afternoon. Again, this is Scott Horton, attorney with Horton Law PLLC. I am presenting today's webinar on New York wage deductions, what may companies withhold from workers' pay. We're going to walk through this in a fair amount of detail. As always, I will answer questions primarily at the end, but I encourage you to type your questions into chat as you have them so you do not forget. If by chance I see a question that I can answer quickly as I'm going, I will. Otherwise, don't worry, I will answer the question at the end. We will have a slideshow as we go with most of the information that I'm discussing on screen, and more importantly, so you can have it after the fact as a reference. So at the end of the presentation, I will provide a link to download the slides. Just a final reminder, if you have any trouble or lagging or any issues hearing me or seeing the presentation, the first thing you might want to do is try seeing if you have any other windows or applications that you can close down, as it may be a resource issue on your device, but otherwise, hopefully everything works fine. Just remember, as you're typing in chat, if you do ask any questions, there will be other people beyond me who may be able to see them or may hear my answer. So keep confidentiality in mind and recognize there is no attorney-client privilege for any discussion during this webinar. And if we need to have such a conversation, let me know afterwards. So here is the overview of what we are looking to cover today. New York law in particular has pretty extensive restrictions on what employers can and cannot withhold from employees' pay. We're going to talk about what employees' pay includes, what employees are covered, and which employers are covered in a moment. We're going to talk in detail about which deductions are allowed and under what circumstances they're allowed. And in doing that, we're going to also identify a few particular categories of things that employers may want to take out of employees' pay, but they specifically are prohibited from doing. There are two kind of special but related topics at the end of the presentation. One is on recovering overpayments. What happens when an employee's been paid more than they apparently should have been? Can you make deductions from future pay to recover that? And we'll describe the circumstances where that's allowed. And we will also discuss the topic of wage advances. And this is a situation where the company has intentionally given the employee more money than they have yet earned, with the expectation of recovering it through future payrolls. And there are ways that that is allowed in New York, but you have to follow specific requirements and procedures. At this point, I just want to start making this a slightly interactive presentation under the circumstances. You won't be able to speak to me and ask questions verbally, but you will be able to ask questions in chat. But I can also ask a couple of kind of survey questions. And the first one I just wanted to throw out is about how your company handles payroll. So just out of curiosity, this is anonymous. Is payroll something in your company that's done entirely within the four walls of your business, or is it just passed off almost entirely to an outside company, or is there some combination of the two? So I'll give you all a few seconds to respond to that. Just thought this might be of general interest to everyone listening. I mean, anyone involved in payroll, among others, in an organization should know these restrictions and be careful to look out for them when they might come up. So far what it's looking like is we have a relatively small number of companies where payroll is handled entirely in-house, and that's not surprising. And then a fairly even split between primarily through a payroll company and then processing in-house with final processing by the payroll company. Maybe you send off everything and then the company does the checks and direct deposits, for example. So that is good to know, just out of curiosity as we're going forward, just something to keep in mind how your company is set up, and depending on what your different function is. Really, I would just suggest it's going to mostly be the employer's obligation to make sure that none of these prohibited practices are taking place, and for figuring out how to accomplish the permissible deductions, rather than just expecting your outside payroll company to handle that. Not to say that there aren't some circumstances where the outside payroll company would catch these types of issues and concerns, and perhaps you have an arrangement where they're expected to catch it, but I would not assume that that is the default. Okay, so let's get into this. And New York Labor Law Section 193, for your reference, is the primary statutory provision that we will be talking about today. And Section 193 of the labor law probably covers most, if not all, of your businesses, at least with respect to employees in New York. and we'll cover that in a little more detail in a moment. But basically what the law starts out by doing is saying that no employer shall make any deductions from wages. So the premise is you can't take anything out of wages that are owed to employees. But then it does say except, and then there are a number of exceptions. So the key here is what are the exceptions, and the exceptions are the types of things that can be taken out of employee pay. So the law goes on in many more words, but I thought in relevant part you should have this language to at least see, to say whenever an employee who is engaged to perform labor shall be promised an agreed rate of wages for his or her services, it shall be unlawful for any person to request, demand, or receive or return donation or contribution of any part or all of said employee's wages, salaries, etc. Any person who directly or indirectly aids, requests, or authorizes any other person to violate any of the provisions of this section shall be guilty of a violation of the provisions of this section. So technically the company could be liable for improper wage deductions, and individuals involved in human resources, payroll, or other aspects of management could also be held responsible for those violations. Usually it doesn't come to that. Usually the company is able to make good on any violations that come to light, but you should know about that, and that combined these provisions mean that both you can't take certain money out of the wages, and a company can't separately require an employee to pay the company money back out of wages earned. In other words, cut a separate check. The caveat on that is it's not to say you can't ask them to return or to make a payment back to the company, but there's a provision in here that I left out before just so I could highlight it now. It is the piece about understanding that failure to comply with such request or demand will prevent such employee from procuring or retaining employment. So what you couldn't do is go to an employee and say, we can't make this deduction from your pay directly, but if you don't cut us a check to return the money that we think you have cost us in some way, shape, or form, then you will be fired. However, if you feel the employee owes the company money for some legitimate reason, you could ask the employee to repay the money, with the understanding that if the employee said no, it would not affect their job. They could not be disciplined, although the company might be able to separately initiate a legal procedure to try to recover that money. And I will try to point out some examples as we go on where that might realistically become an issue. Obviously a few dollars here and there, the company's not going to go sue an employee and hopefully not threaten to fire the employee if they don't get the money back. But in more extreme situations, that could become relevant. So important to kind of cover off up front some of the definitions here. Not that I expect anybody to memorize the word, just so you kind of know what fits in and what doesn't fit in. Employer is defined pretty broadly as any person, corporation, limited liability company, or association employing any individual in any occupation, industry, trade, business, or service. So really there are very few exceptions to what qualifies as an employer. The only meaningful exception is a government agency, which does exclude pretty much any public sector government entity, state, city, county, town, school district, public authority, but does not carve out any private, either for-profit or not-for-profit businesses. So if you are not the government in some way, shape, or form, and you have employees, then Section 193 applies, at least with respect to those people working in New York. Another critical term here is wages, because what the law talks about is deductions from wages per se. Wages are defined to mean the earnings of an employee for labor or services rendered, regardless of whether the amount of earnings is determined on a timepiece, commission, or other basis. Intended to be broad, just want to note that wages include benefits or wage supplements, which is another legally defined term that includes things like reimbursements for expenses, like mileage or meals, health and welfare and retirement benefits, vacation, separation, holiday pay. So overall, it's pretty much any money that the company is paying to an employee related to their providing service or work for the company. The main exception would be if the company were actually buying something from an employee, then that money that the company is paying to the employee would not be wages. It would be just, sale proceeds, for example. So, if you happen to have an employee who has their own business or separately manufactures or owns something that is of interest to the company and you purchase it for them, then that transaction wouldn't be a payment of wages, most likely. On the other hand, if you have an employee whose job is to build something and provide it to the company, then there's a reasonable chance that whatever money is paid to that person in exchange for producing that item could be considered wages. The other line to be drawn when you tie all this, before I go on, together is the slight distinction between employee and non-employee here. So kind of alluded to it a little bit in that discussion. If it's clear someone is an employee and working for the company as an employee, obviously, then these provisions apply and the payments are wages. The exception would be legitimate independent contractors. For example, you're buying something from a wholesaler that you're going to sell in your business or use in your manufacturing process. That wholesaler presumably is involved in a separate business operation of their own, and therefore they're either just not an employee or worker or anything like that, or at most an independent contractor. So there are some cases where there's a fine line between classification of employee and independent contractor or consultant, for example, that comes into your workplace. May or may not be an independent contractor, depending on how much control over their work the employer has and other factors. Whole other issue that we don't have time to get into right now. But if you did have someone as either a separate business or a legitimate independent contractor, then the payment to that person would not be wages and these deduction provisions would not apply. Now, with all of that background, hopefully you got an idea of who this applies to. I suspect, having basically looked at people that have been registered, that most all of you are with private businesses, so that the exclusion for government entities is not significant. So now we get into the real meat and potatoes of what is allowed and what is not. So broadly speaking, the law discusses 4 categories of permissible deductions. They're kind of wordy. I mostly use the legal language just to kind of make sure we don't misstate anything, but I will summarize this a little better. The first item is deductions made in accordance with any law, rule, or regulation issued by any governmental agency. In other words, something that the law already requires to be deducted. And we're going to go into all of these in more detail. The second category would be voluntary deductions for the employee's benefit and expressly authorized in writing by the employee. So these are the insurance benefits that you offer, for example, and take premium contributions out of pay would be one example falling into that category for the most part. And then there's 2 other specific items that we kind of alluded to earlier. They're the deductions for the recovery of overpayments made in accordance with Department of Labor regulations and deductions for the repayment of wage advances made in accordance with DOL regulations. So here, just to go through those, the first one is the easiest to sort of check off: deductions in accordance with the law. I hesitate to call these mandatory deductions because not all of them are, but more or less that's what we're talking about here. These are your tax withholding, state and federal, your wage garnishments and levies, where you get a child support order and you have to take money out of the employee's pay consistent with the court documentation, or someone has a judgment against them and their wages have been levied or garnished. So those types of things you have to do. Pre-tax contribution plans. This recognizes especially that federal laws dictate some of what happens on the types of deductions for not only certain 401k plans and the like, but also some tax favored benefit plans as well. So certainly if there's another law that expressly says employers can make the deduction, then employers can make the deduction. Beyond that, and the ones that are generally the trickiest sometimes to figure out, are the voluntary deductions. The voluntary deductions have to now fall into a specific statutory category, which is somewhat helpful, although not entirely, as I'll describe in a moment. This law changed about almost 10 years ago, 9 years ago now. The law was more general and less specific at that point in time. It didn't have these specific categories. It just referred to voluntary deductions for the employee's benefit, with a little bit more wording. But now the statute lists a bunch of specific authorized deductions or authorizable deductions, which was really, I think, designed to make it clear that there were certain things that employers could deduct as long as the employee agreed. It wasn't necessarily intended to tie employers' hands. But in another way, it kind of does, because it now says if you don't fall into one of these statutory categories, it can't be done. So there's a little bit less gray area now. But it does still have to be for the employee's benefit rather than the employer's benefit. Although if there's some benefit to the employer that's incidental to the employee's benefit or that goes along with the employee's benefit, that doesn't necessarily make it an impermissible deduction. And the employee must authorize the deduction in writing in advance without revoking. Without revoking meaning that anytime an employee agrees to have a deduction for one of these categories of benefits, they have the right to revoke that authorization at any time. That's not to say they can show up after payroll has been run and suddenly say, don't deduct this from today or tomorrow's pay. There are guidelines that say that the employer has to honor the revocation within 8 weeks or 4 pay periods, whichever is soonest. So you do have some time once it's revoked, but you can't just say, no, once you authorize it, we're going to do it as long as we like. So here are the categories. I'm not going to read all of these, but some of them are pretty standard and obvious: insurance premiums, pension or health and welfare benefits. So your health insurance, if you had life insurance or disability, long-term disability insurance, or something that the employee is paying for through their paycheck, that's acceptable. Contributions to a bona fide charitable organization, the United Way, for example, is okay. On here you see dues or assessments to a labor organization. So union dues can be taken out and paid to the union. And then there's other categories that are more specific. Some of these actually arguably are already covered by the allowed by law deduction, because there are things like flexible spending account that are tax favored. pre-tax, that is, deductions and the like, but just to avoid too much confusion, they've added those to this list. So if you have employees deducting money from their pay for daycare expenses, potentially in a pre-tax plan, or doing any of the other things on this list with a written authorization, then it is okay. Some of the items that were specifically added intentionally to clarify that these types of deductions were okay back in 2012 were, for example, the cafeteria and vending machine purchases made at the employer's place of business, and purchases made at gift shops operated by the employer, but only where the employer is a hospital, college, or university. These were settings where it was typical to have people on site long enough and often enough that they would need to make repeated transactions, and maybe it's just easiest to give them a card that they can swipe, for example, and then have that come out of their pay. But there are limits on how much they can, use at any time, or at least they have the right to set limits on that. So some of these go into more detail, and you should check the regulations further if you're not familiar with using these types of deductions. But this is the first step in deciding whether a voluntary deduction can be made. So I said it has to fit into one of these listed categories. The interesting thing is the last of the listed categories specifically says, and similar payments for the benefit of the employee. So it raises the big question, what is a similar payment to any of these listed, since many of them are already rather specific? Similar payments have some parameters. Again, they're not specified per se, but the first thing to note is mere convenience is not enough to qualify as a benefit to the employee. They have to provide financial or other support for the employee, the employee's family, or a charitable organization. And they must fall into one of these categories: health and welfare benefits, pension and savings benefits, charitable benefits, representational benefits, which really just means union benefits or union fees or dues, transportation benefits, and food and lodging benefits. I am not really able to tell you too many things that would specifically qualify as a similar payment that are not already on the list of voluntary deductions. Basically, if you can't read one of the specifically enumerated deductions in a way to include what you're thinking about deducting, and the law doesn't otherwise require it, then it's certainly questionable whether it would qualify as a similar payment. In other words, if what you really just need to do is figure out exactly what a pension or health and welfare benefit includes, that's one thing. Dues or assessments to a labor organization might come in different shapes or forms. They may be okay as similar payment, but if it's something else entirely that's not on this list, then I think you would be reluctant to consider it a similar payment. Okay, so assuming you have something that looks like it is deductible with authorization, then you need to worry about getting the proper authorization, and there are parameters for that. You do need a written agreement. Doesn't mean it needs to be a formal contract per se, but there needs to be some writing between the employer and the employee or the union. So you can authorize these deductions through a collective bargaining agreement with the union on behalf of the employees it represents. The regulations do specify that the authorization has to be in at least 12-point font. So, maybe double check, or at least if you're using these forms going forward, see if you really have 12-point font, because again, that is a relatively new regulation, at least in the last decade, probably. So if you have older forms or just never knew that was a criteria, then you might want to update that. The authorization does have to be express, written, voluntary, and informed. So what does that mean? Well, obviously it has to be written, express. I mean, that's to specifically say this is what is authorized. Obviously it has to be voluntary, meaning you can't hold a gun to the employee's head. Figuratively, that is. Hopefully nobody would do that literally just to get an authorization to take money out of somebody's pay. And informed means the employee is provided with written notice of all the terms and conditions of the deduction, its benefit, and the details of the manner in which the deductions shall be made. Let's break this down a little bit. So you have to, in the authorization, or with the authorization at least, put in writing what is going to be taken out, how much, how often, what it's for, and it has to be one of those items that we've already discussed. Again, this is for the voluntary deductions. You wouldn't need this to take out federal or state income tax withholdings, for example. The employer then also has to provide a notice before any change in the amount of a deduction or a substantial change in the benefits of a deduction. The wording on this in the statute and the regulations gets a little complicated. Arguably, if you didn't give notice because you're taking out 12 cents less than you were before or something like that, then I don't think it's a big deal. The notice requirement is more specific that before you increase the amount of any deduction, you have to give advance notice. Otherwise, you have to give notice as soon as practicable, which arguably might be with the paycheck, for example, in which the change is being made. Most typically, if you're taking deductions for health insurance or something like that, you're notifying the employee up front. They know what they're getting themselves into. They're either changing their health insurance or you've told them that the rates and contributions will change. But again, this is something you have to do for any deduction that you're going to make a change to. The other requirement is that the authorizations be retained for at least 6 years after the respective employee's employment ends. I don't know whether anyone has a careful enough retention policy that they're going to then destroy such documents on the 6-year, 1-day mark after somebody's employment ends. I would just say make sure you keep them for as long as you reasonably can, or as long as you keep the personnel files, for example, or any pay compensation related files for employees, and assuming that's already at least 6 years, because that is the statute of limitations for most of the New York labor law, wage payment, minimum wage, and overtime types of requirements. Okay, now that we've covered what can be taken out of wages, with the exception of the recovering overpayments and advancements, which we'll get back to, we need to briefly talk about the few specific items that, no matter how you try to read the previous slides, cannot be taken out of employees' pay. So employee purchases of tools, equipment, and work clothes. So if you have employees who are expected to use their own tools in performing the job, that might be acceptable, but you cannot effectively sell the tools to them and take it out of their pay. If you are an operation that does sell tools for whatever reason, whether available to your employees or employees and other members of the public or something, then that's not to say you can't sell tools to your employees. They would just have to pay by separate transaction. Fines or penalties for misconduct. So you're more limited to suspending someone for future work rather than taking money away for past work in cases of misconduct. So if someone has showed up for work late too often, and you want to suspend them next week, in which case they will neither work nor get paid, that is fine, but you can't look back to the previous week and say you were late so often that week that I don't even want to pay you for the time you were here. That would be unacceptable under New York law. The other major category, and something that in particular would be allowed in some other states, is repayment of employer losses such as spoilage, breakage, and cash shortages. So retail employees whose cash drawer comes up short at the end of their shift, they can't be required to have that money taken out of their paycheck. Now, that's not, again, to say that theoretically you couldn't have an employee who says, I feel so bad that we came up $50 short, I'm going to give you $50. By taking the money, the company doesn't violate the law. They just can't deduct it from the pay, and they can't tell the employee, if you don't give us that $50, then we're going to fire you, suspend you, discipline you in some way, shape, or form. Similar for situation where employee causes damage to company property, whether that be breaking an item or doing damage to machinery or the building itself. That could constitute vandalism, for which there might be legal consequences, and you might, depending on the value of the damage, be able to sue the employee to recover for the cost to the company of repairs, for example. But likewise, they could not be fired for not repaying the money. That is a slight distinction that I want to make between firing them for carelessly or intentionally damaging company property. I mean, in that situation, you could say, well, you ran a forklift through the wall. We don't want you working here anymore. But it would need to be separate in part. If you had two people who ran forklifts through the wall, and one of them offered to pay $1,000 to get the wall fixed, and the other one didn't, and you fired the one who didn't offer to pay something, then you might have a problem. Okay, with that, we're going to move on to basically our two special categories of recovering overpayments and then wage advances, because there are a lot of nuances connected with these issues. Okay, so overpayments can be recovered under certain circumstances, but only if the overpayment is due to a mathematical or other clerical error by the employer. Couple important things here. First of all, the error has to be by the employee. If you've overpaid someone because they claim to have worked more hours than they actually did, then these overpayment requirement or regulations are not relevant. In that case, honestly, you could not make a deduction. You would have to pursue other means. You may be able to discipline or fire the employee for falsifying their time record, and you might even be able to sue the employee to recover the money, but you could not take it out of their pay. It also has to be due to a mathematical or other clerical error. What exactly qualifies as a clerical error could get dicey in some situations. There's no elaboration on that in the regulations, but it is clear enough that if you just said, well, we're going to pay you for 40 hours this week because we don't know how much money or how many hours you actually worked, and then down the road the company decide, oh, now we think that you worked 20 hours and we need to get that $20 back, that's probably going to be a problem. What's really intended here, and I put this old-fashioned sort of ledger sheet in this picture. Maybe it was easier to make clerical errors when it was done by paper and pencil. Now with computers, hopefully at least the math is being done correctly. The bigger problem is probably with the data entry. So, any of those types of mistakes where somebody added 10 hours on Tuesday and 8 hours on Wednesday and came up with 16 hours, that's a mathematical error. A clerical error would include the data entry errors where we just forgot to move one pay or one day into vacation or something like that, even though we had the record to know we should have. So again, there's no finite scope of what that includes, but there is kind of a general understanding of what it doesn't include. We're going to go into more detail, but there are limitations on the timing and amounts of recovering overpayments. And you do have to formally create a notice and dispute procedure and give notice of that to the employee in connection with making these overpayments, and then follow that procedure in ways we'll discuss. And if you do satisfy all of the requirements, you can accomplish the recovering of the overpayment either by a wage deduction or a separate transaction. So it gets a little complicated to explain why that's relevant. So again, primarily we're talking about what are you taking out of wage payment. But as I mentioned before, you could, in most cases, ask someone to voluntarily pay the company back. Here is a situation where if you follow all of these details, arguably you could actually take disciplinary action, fire someone, or let them know that you're going to if they don't pay you back by separate transaction. I'm not really familiar with situations where it happened that way, but I think the regulations leave that as an open possibility. It's normally the only situation where you wouldn't be taking it from future wages is where there aren't future wages, in which case threatening to fire someone if they don't pay you back the money may be irrelevant, as they're already not working there any longer for whatever reason. Okay, so on this slide, it kind of summarized the timing, duration, and frequency limitations. First of all, you can only go back 8 weeks before notice of overpayment to an employee. So what this means is if you discover a mathematical or clerical error that took place 6 months ago, it's too late to use this process. Again, maybe you could say, hey, we realized we paid you more than we should. Would you mind paying that back? But you couldn't fire them if they say no. It's 8 weeks before the notice. So if you find this out and it's literally been 7 weeks and 4 days since the payday where this money was improperly paid to the employee, you better hurry fast to give them notice of the overpayment. If it's 8 weeks and a day, then you're stuck. What I have seen happen is situation where someone was repeatedly overpaid, even arguably in that case based on a clerical or mathematical error, and the overpayment started more than 8 weeks ago but continued within the 8-week span. So in that case, you'd be able to go back the 8 weeks, but you couldn't go back further. So once you identify how much overpayment and make sure it's within 8 weeks, then you can recover that amount through deductions lasting up to 6 years from the overpayment itself. So most of you are probably thinking, why would I ever want to wait 6 years to recover all the money? Do we have to spread it out over 6 years? No, in most cases you wouldn't have to, but there might be a scenario where it could take that long. I mean, imagine somebody who works part-time and makes so little money that it will take them 6 years to even earn the amount they were overpaid. Then, I guess it could push that, but in most cases, it's not going to take that long to make the deduction. And we're going to talk about some actual limits on how much each deduction can be on the next slide. The other thing, just because the regulations mention it, it's not critically important to keep in mind, I don't think, but it's kind of intuitive. There's no more than one deduction per wage payment. So you can't, say, well, we're going to deduct this through a series of $50 deductions over the next 6 pays, and then for some reason say, well, this week we're going to take 2 deductions instead of 1. Whatever you can do, you figure it out on a per wage period or per payday basis and take it on each payday. Okay, so what amount of deductions can be made? There's a couple important distinctions here. The first is that you can recover it in full on as soon as the next payment, but only in a situation where the overpayment amount is less than what the employee will make in the next payroll. So if they were accidentally paid an extra $100 that you can recover, and they normally make $600 a pay period, then you could take the full $100 out of the paycheck. One note that this does have to be net of other deductions, so you can't take away more than the full amount of the check. So once the taxes come out and any health insurance contributions and whatever, you can't run the check negative. Otherwise, your recovery in any given payroll cannot exceed 12.5% of the gross wages in the payroll. Now, this would be gross wages before the deductions. So if someone makes a salary of $600 a week and you need to deduct $1,000, for example, then you can't deduct the $1,000 on the next payroll. You have to spread it out, and the most you could deduct in any given payroll is 12.5% of the $600. So say $75 per week. So to get the $1,000, it is going to take you, 3 or 4 months to get that money back. Again, 3 or 4 months, a lot less than 6 years, but if there was enough money overpaid and the person does make enough, a little enough money, then it could take a while to recover it. The other thing is that in any given payroll, this deduction can't reduce the employee's pay below minimum wage. So whatever the operative minimum wage would work out to be per hour, the deduction, even at 12.5% of their gross wages, couldn't also reduce them below the effective minimum wage. I'm not going to try to do that math because it's not worth the time and the confusion, but note that that is an important parameter. So when you give the notice to the employee, you have to state the total amount that you believe was overpaid on a total and per pay period basis. So if it was a one-time thing, say we took out we gave you an extra $800 on this payday, or if it was over 4 payrolls, then this is how much from each of the respective pay periods we paid you more than we should have. You have to include a schedule of deductions. The schedule of deductions is probably the best you can do. You may not be able to do the exact dollar amount because of the 12% and minimum wage limitations. So keep that in mind. You also have to give in this notice an explanation of the procedure for disputing the deductions, giving the employee a chance to say, wait, I don't think you should have taken this money out. And we'll go into more detail on that. And then you have to notify the employee that they either have 3 days or 3 weeks before the deductions could begin The 3 days applies in the case where you're going to be making the full recovery in the next pay period, so where it's a relatively little amount compared to the employee's pay, less than their take-home pay. You only have to give them 3 days notice. Otherwise, you have to give them at least 3 weeks notice before the series of deductions begins. What does the dispute procedure have to look like? Well, to kind of simplify it for summary purposes, the employee has a week to respond to the notice. The caveat on that would be that in the case where you're going to deduct in the next payday, on the next payday, and you've told them they only have 3, or you're going to start deducting in 3 days, they have 2 days to dispute it, which for some of you will be problematic anyway because your payroll is run more than 1 day in advance. So I would just say, even if you're going to do it the next payroll, you don't have to, unless you're really up against that 8-week limitation, give the notice so your next payroll is not 3 days or less away. Employer will then have, if the employee says, I'm disputing the deduction, the employer has a week to respond to the dispute in writing, after which the employee has a week to say, I want to meet with management to discuss the situation. And then by a week after that, the employer has to issue the final determination. So the law does give the company the right to make the final call on whether or not the overpayment was made and the deduction is appropriate. So at that point, you can then proceed to make the deduction, but you still have to wait another 3 weeks after the final determination for the deduction to be made. I presume that would be to give the employee time to go to the Department of Labor or an attorney to try to more formally dispute the company's position. If the company has followed the procedure appropriately and given all the right notices and calculated everything well, then you should be okay with the Department of Labor or whatever other remedy the employee might seek. If you have not followed this procedure properly, then the Department of Labor is going to just presume that there was no overpayment and there can be no deduction. So important to do this right, or else you may lose the ability to recover the money. All right, so now we move on to our next special topic, and that is the subject of pay advances. So pay advances are two different things depending on your perspective, but let's focus on what they are for purposes of the law and what we're talking about here. They would be providing money from the employer to the employee based on the anticipation of earning future wages. Employee says, I can't make my rent payment this month. Can you give me $500 and take it out of my pay next month or over the next 2 months, for example? The other type of scenario where something might be thought of as a pay advance but isn't going to qualify under the New York law and regulations is really what would more properly be characterized as a loan. Because if there is any interest or fee attached to the repayment, then for legal purposes here, it's not an advance and can't be recovered through wage deductions. Again, to clarify, this doesn't mean you can't give a loan to your employee. The owner of a business might have a friend or an employee working for him who, he wants to help out and even give, say, a $10,000 loan repayable over some period of time, and both agree that there's going to be interest or some other form of additional repayment beyond the amount that's given in the first place, the $10,000. That can be done. The company just can't take the money back through wage deductions, nor can it fire or discipline the employee for not paying the money back. If you want to have a promissory note or something like that and sue the employee if they don't repay, then that's not necessarily impermissible as long as it's done, otherwise legally. But again, you couldn't take it out of the wages. So what is allowable in the $10,000 case, even you could have an arrangement where the employee is going to get $10,000 and you're going to take the $10,000 out in, say, $10,000 installments if the employee makes enough money to cover that. But you couldn't say, here's $10,000 and we're going to take it out by $12,000 deductions, effectively returning $12,000 to the company when they only gave up $10,000 in the first place. Even if, based on interest rates and time value of money and that sort of thing, it would be reasonable to do that. You just cannot under the labor law. Okay, so where you can do this, again, we need an authorization. The employer and employee must agree in writing to the timing and duration of the repayment deductions before the advance is made. The employee, after signing that agreement, still has the right to revoke it up to the point when the advance is made. Now, they don't have the right to get the money and then say, I don't like this deal. But if they sign it and it's 3 weeks before it was going to be taken out of their pay, or even a week out of their pay, or theoretically even a day before it's going to be taken out of their pay, they could come back and say, no, I've changed my mind. I don't want to do this. It means they don't get the money. I just happen to see this quick question. Are the slides available in PDF? Yes, they will be at the end. We're almost done too, and you will get the link to that in a minute. So you don't have to feel like you need to copy all of this or take screenshots. And yes, there will be a replay video recording of this available as well sometime tomorrow. If you're registered for this, you will get that by email. Again, some of you have asked questions. If you have any questions, then go ahead and start typing those in, and I will stay on and answer all the questions after we wrap up. Sorry for that, but I just wanted to touch on those so those of you who are wondering the same thing have the answer. Okay, so we get to the situation where the employee wants to revoke. All right, we're just going to stop everything. It's not going to happen. But the authorization also has to include a notice that the employee can contest any deduction as not being in accordance with the authorization. So here, there hasn't been a revocation by the employee. The advance has been paid, and then the company starts deducting the money back from future pay. But the employee says, wait a second, you're taking more than you should, or you took it faster than you were supposed to, or whatever. There has to be a predetermined process to address that. Here are a few of the conditions around that. One thing that the law specifies, or the regulations make clear anyway, is that once you've entered into one of these arrangements with a particular employee, they cannot have another advance subject to these procedures. So you can only do this one at a time. So if you've agreed to advance someone $5,000 and it's going to be paid back over whatever schedule, until it's repaid in full, you can't then make another advance of any amount. The Arrangement can provide for total reclamation in the last pay period in the case the employee is terminated from employment. So if, for example, you've given $6,000 and we're going to take $500 each out of the next 12 paychecks, but the employee only works through the next 10 paychecks, then the remaining 1,000 or really 1,500, because there's the one from that paycheck too, could potentially all be taken out of that final paycheck. On one hand, that assumes there's enough money in the final pay to do it, but it also, keep in mind, could include things like their payout of vacation or other types of benefit payouts. So often, or at least in some cases, that last paycheck is bigger than a regular paycheck. If you did have a severance arrangement or something like that, where you're offering the employee, for whatever reason, additional money that they weren't otherwise entitled to, you could likely also address that in that severance pay. Depending, I mean, if you have a existing severance pay policy, then that money might qualify as wage supplements, but in which case it would still be wages, and in which case you could probably still deduct the pay advance amount from it. But you'd have to look into those particular issues at the time. So finally, as I mentioned on the last slide, the employee can object to any deductions in writing. And once that happens, the employer has to stop the deductions until they reply with their position. So there's not quite as many specific limitations and procedural requirements as there are for overpayments, because you've already agreed to this up front before even giving the money, unlike the overpayment where the employee just got the money and is good to go. So you could put whatever procedure you need in to satisfy both the employee and the company, as long as there's the allowance that once the employee says, I don't think you should be making these deductions, the company has to stop until they at least reply with their position, which case they can go on making the deductions, subject to the employee going to the Department of Labor or hiring an attorney or whatever and saying, wait, we don't think you should do this. Okay, so I'm going to just give some final thoughts here in just a second. But just to follow up on that last discussion, I thought it would be interesting just to ask whether any of your companies do allow employees to receive pay advances. So just real quick, also this would be a good time to think about getting any questions in, because we're just about to wrap up. I'm going to give you the link to the slides, and then I'm going to go into the questions. So at least a few of you here do have or have allowed pay advances. So just keep these procedures in mind and make sure you have this in writing and you're not charging interest and those types of things if what you're doing is then deducting it from wages. But I just thought it'd be interesting to those of you participating to see that it looks like about a quarter of you do allow pay advances in some situations. Kind of interesting thing, another reason I wanted to discuss this is, you can't call something a pay advance after the fact as a result of this sort of regulatory structure. So you've given the money up front accidentally or intentionally or whatever, and now you want to come back and say, oh, it's an overpayment and we're going to recover it that way. Well, again, you can only recover the overpayment if it was a mathematical or clerical error, not because we were loaning you money. You can only recover for the advancement if it has been authorized in writing before the money was paid. So these things all start to tie together in that respect. So with all that in mind, I encourage all of you to review your existing deductions if there's anything that might be questionable, or even just again to make sure you even have the 12-point font on your authorizations. Not sure you're going to get in tremendous trouble if it's 11.5-point font, or if it happens to be a font that's larger than other fonts in the first place. Doesn't say it has to be a particular font, but you don't want to have this in microscopic writing somewhere and then have somebody complain. Analyze any new deductions carefully. You'll have the copies of these slides to review back to if somebody in the business decides, oh, can we start taking money out for this? For example, we want to have a company or employee pizza lunch every quarter or something like that. Can employees take $1 out of their pay here and there to cover the cost of that? Off the top of my head, I would say no. But this is the structure that you have to go through to reach that conclusion. And if you are doing pay advancements or trying to recover overpayments, make sure you walk through these requirements carefully. Don't try to characterize recovery of an overpayment as a pay advance. In other words, we paid you the money before we should, so now we're not going to pay you next week. Isn't going to work unless it was agreed to up front or you're otherwise allowed to recover the overpayment. All right, so just a second, I'm going to post the link to these slides. Just encourage you, well, this is not necessarily a new topic. These regulations and the statute have been around for a while, but I think it's an important topic to be reminded of. A lot of our discussion lately has been about issues related to COVID and various leave requirements. So the fastest way to get updated on any of that is to follow us on LinkedIn if you're there. If you're registered for this webinar, then you should get our email newsletters if you want them. You will get an email tomorrow with the confirmation of your attendance if you've attended here live the webinar, in case you need that for any accreditation purposes, etc. We're not pre-approved for any credits, but I know some situations you can or need to verify that you've attended educational programs of this type. So we provide that confirmation, and that will have a link to both the slides and the recording of the presentation itself in case you want to watch again or share it with a colleague. But here, if you want them right now, is the link to the slides. And while you are getting those, if you want them, I am going to start reviewing the questions and answering them. And you type in questions as you have them. I will stay on to answer them, but thank all of you for attending. If for whatever reason you are not going to hang on for the question and answer. Okay, so I have a question about final pay deductions. We talked about the specific scenario where you have a wage advance authorized. You can recover that in full from the final pay deduction. Otherwise, the basic rule is going to be you can't just change the amount of deduction to meet the balance or whatever just because it's the last paycheck. And we talked about how the authorization has to identify the amount and there would have to be advance notice of a change in the authorization. So with that in mind, the specific example of I'm envisioning a scenario where the employee has been out of leave for some period of time, but their insurance has continued, their health insurance in particular, and there hasn't been a paycheck to deduct their employee contribution from. So let's say they owe a few $1,000s even, or hundreds of dollars at least in insurance premiums, but normally they only get a certain amount taken out of each paycheck. I suppose theoretically you could notify the employee that the additional amount is going to be taken out. The employee, however, would have the right to revoke their authorization at that point, in which case you would have to do it. So I think it's going to really depend practically on what the employee wants to have happen. I suppose you could just try it and hope they don't realize that they could probably revoke it if they don't like the idea. So, but again, typically the right thing to do would be to disclose that and discuss it with the employee, whether they want it to be deducted. And then if they do, ideally you get that again in writing, so there's no uncertainty in case the employee comes back after the fact. In a more specific situation where you're just going to try to do it without the employee's authorization, then I would suggest speaking to counsel on your specific circumstances. And I think the way the question was asked, I've probably discussed the other items. You can advance it for wage advance recovery. As far as a loan made to the employee, again, if it's technically a loan, you can't deduct anyway. And the question for excess time off, that would be pretty specific to a situation, but again, note the limitation on making deductions due to fine as a fine or penalty for misconduct or something like that. The employee shouldn't have been paid for time they weren't working. I guess where this could come up is if the employee used more PTO than they had available, running a negative balance in their PTO, for example. I think the gist of these wage deduction laws, and I've dealt with this in particular circumstances several times, is you shouldn't be having employees run negative PTO balances, and you probably won't be able to recover that at the end of employment. But again, that could depend on the specific circumstances and exactly how it was set up. I have a question here. If this person who asked the question is still around, could you clarify? It says regarding EWA, in conversation with the New York Department of Labor, they said the law is not kept up with technology. I'm not at the moment recognizing what EWA means. It may well be that it's something I just talked about, but if you could just clarify that, it'll help me answer that question. All right, I have a question that says, if you have salespeople that make commissions and they're paid commission on a sale that later becomes bad debt, the client never pays the company, can that commission be recovered by the company? What if it is written in the commission plan signed by the employee? So it's a good question. I'm glad you brought it up. I was hoping and thought that somebody probably would ask about commissions. So the issue with commissions in New York is basically, if you have commission salespeople, you're supposed to have a written commission agreement. Sounds like in this case, it's suggested that there is one, so that's good. The commission agreement can, generally speaking, be set up however you like, in the sense that you can define the commissions in an infinite number of ways. What becomes important for the purposes of the wage deductions is what have you identified as constituting an earned commission. So, for example, you could have advances against commissions and that sort of thing, but at what point does the money become earned? If the agreement, for example, says you get 10% of the sale amount on everything you sell that is paid within 10 days after invoicing, then that person is entitled to just that. If after 10 days after invoicing, you do the calculation and then you pay the commission, and then later, for some reason, the company has to refund the money to the customer, then you don't get to go back and take that money away from the commissioned salesperson. They've earned it because the money has been received based on the terms. If, on the other hand, the question is a bad debt, the client never paid the company, then we're not talking about the situation that I just described. Now we're talking about a situation that says, for example, you'll be paid 10% of all sales in the preceding month by the last day of the following month. So whatever you sold in January, we're going to give you 10% of that by the end of February. Well, if it's written that way, then arguably the fact that the employer never received the money from its customer is irrelevant because there was a sale and what's the amount of the sale. So it really all comes down to how the agreement is defined in the first place. But if, however it's written, the point, I guess, is if it's written in a way that says the employee has earned it and the employee has been paid it, then at that point, there could not be a deduction unless it qualifies as an overpayment due to a mathematical clerical error and you use the procedure that we talked about. So if the problem was somebody miscalculated the commission, then that would be a different situation. All right, next question I have is, if an employee wants to purchase a shirt or hat, can they have it withheld from their check if they request? No, unless they're buying it from a store in connection with a university or college or hospital. So in those limited, that was one of those specific limitations. For the most part, no, they would have to buy it from a separate transaction. So that was a limited exception allowed. And because it was so limited, it's pretty clear that the alternative can't be done. If I will double check afterwards, and if I come up with any further clarification that I think might be relevant on that, I will let you know. You will get an email on, you'll get an email tomorrow that will link you to the slides if you didn't get it, but it should be up now. You should have it available to you. If not, then I can also email it to you after this. We're back to the EWA. Earned wage access is the employee given access to a portion of the net earned and accrued wages. The amount and fee is deducted from their pay. I'm just going to be honest, I'm not familiar with what exactly that is right now, so I can't really better help you with that. So I think that is all the questions that I see. I know a couple people mentioned that they would contact me separately with a question. That's good. We can do that too. If there are any more questions, now's the time to start typing them in. Even if you just say I have a question, and then I'll wait and listen and wait for your question to come in next. But I'll give you maybe 30 seconds to ask any final questions. In the meantime, thank all of you for attending and participating. Yeah, that's fine. We can connect separately so I can get clarified on what your EWA point is. And then we typically have webinars about every month, not necessarily every month. So if this is your first time attending one of these webinars, thank you. If you're registered here, you will get the newsletter and emails about our future webinars. If you don't want those, you can easily unsubscribe, let me know, or there's a button in those. Otherwise, if you find these helpful, please do continue to attend. The questions are much appreciated, makes it more interesting than just listening to everything I had prepared to say. So with that, I don't see any more questions, and I will just wrap up. And again, you'll get the follow-up email with all the information again tomorrow and the confirmation of your attendance. Thank you, and have a nice day.